Last week, the Ontario government proposed some big changes to how the landlord and tenant board operates. So I read through the details, I broke down the important ones, and I have a few opinions on them from the legal perspective. I'm Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto, and I help people like you close real estate deals. Now, it's no secret that the landlord and tenant board has its issues, right? Long delays, inconsistent outcomes. Now, these new proposals look to chip away at some of those issues. But one of those ideas would have completely changed the rental landscape in Ontario, effectively eliminating rent control as we know it. But the government walked that back just 3 days after announcing it. So I'm going to break it all down for you. The first proposal here is for rent arrears hearings. Right now, if a landlord files an application against a tenant for unpaid rent, the tenant can raise their own issues, like maintenance, at the same hearing. They don't need to file a separate application, but they do have to provide notice to the board and the landlord in advance. Now, the current law has an exception. If the tenant has a good enough reason for not giving that notice, the LTB will still allow them to raise the issue, even on the day of the hearing. So the government is proposing two changes here. First, they want to eliminate that exception. So if proper notice isn't given, the tenant won't be allowed to raise those other issues, period, no matter how good the excuse is. The idea here is to reduce delays. Fewer last minute issue means fewer adjournments and more actual hearings that proceed as scheduled. Now, in theory, it makes sense. But in practice, I'm not sure how much it will actually help. Right, even with the exception gone, tenants can still raise issues with just a few days' notice. That's after the hearing schedule is already set. So unless the board is currently being very lenient with these exceptions, I don't think it's going to move the needle that much. Now, the second proposal here is more interesting. The government wants to require a tenant to pay 50% of the rent arrears if they want to raise their own issue at the hearing. This would be pretty effective, right? It would shrink the amount of money in dispute at the hearing and require a show of good faith on the tenant entering the dispute process. And to be clear, this doesn't create a new burden on tenants. The RTA already doesn't allow tenants to withhold rent unilaterally, even for legitimate complaints. There is a process for paying rent into the board during a dispute, and that requires its own application. Under the current law, landlords can apply to evict a tenant for paying rent late on a persistent basis. The problem? The law doesn't actually define what persistent means. So even though the option exists on paper, it's rarely enforced. Adjudicators are left to decide on a case-by-case basis, and without a clear standard, most of these applications go nowhere. So the government now wants to fix that by introducing a formal definition through regulation, something like a set number of late payments over a certain amount of time. And honestly, that makes a lot of sense. Right now, persistent late payment is basically an empty rule. It's in the act, but it has no real teeth. So if they want to introduce a clear test, it could finally become a usable tool for landlords dealing with this kind of problem. So it's not a huge change, but it's a practical one, and one from a legal standpoint makes a lot of sense. Next up is a proposed change to the landlord's own use eviction rules. You'll know this as an N12 notice. So right now, if a landlord wants to end a tenancy because they, or a family member, plan to move into the unit, they have to give at least 60 days notice and pay the tenant 1 month rent as compensation. Now the proposal here is to create another option for homeowners. The landlord gives at least 120 days notice. That's 4 full months. They wouldn't have to pay the compensation at all. If the notice is less than 120 days, but still at least 60, then the current rules would still apply and the landlord would still owe 1 month rent. So either give more notice and avoid the payment, or give less notice and pay the month's rent. Whether that extra 2 months of notice is worth saving that cost, that's up to the landlord to decide. This next one here is a small but practical one. Right now, if a tenant misses rent, the landlord serves an N4 notice, and then has to wait 14 days before they can file for eviction at the landlord and tenant board. The proposed change would cut the waiting period in half, so letting landlords file after just 7 days instead of 14. It's not a dramatic shift because most of the waiting time is actually after the application is filed, but it's still a step in the right direction. Any reduction in time for access to justice is a positive thing. And for landlords dealing with non-payment of rent, every week counts. Now, this last proposal was the big swing. And even from my first reading of this, I wrote in our newsletter how vague the language actually was. And it would have had the biggest impact of all. The government announced that it was looking to review how fixed-term leases expire under the RTA. So right now, once a fixed-term lease ends, the tenancy automatically continues on a month-to-month basis unless the tenant chooses to leave. But the proposal was looking to explore alternate options, which could have given landlords more control over whether to renew or end a tenancy when the lease term ends. And if that happens, it would essentially remove the protection that allows tenants to stay indefinitely after a lease ends. And with it, that would eliminate rent control as we know it. So you'll notice the government didn't use that language specifically. They never said the words rent control. And that's because how politically sensitive this one becomes. Right? For homeowners and landlords, the upside was clear: more flexibility, more control, more ability to respond to personal needs or market conditions. But this one was controversial. And just after 3 days of the original announcement, the housing minister already walked it back and said they'll no longer be exploring this option. So, as big of a change as it would have been, it now looks like there is no chance of this actually moving forward. Now, to be clear, none of this is law yet. These are just proposals. The bill still has to go through the legislative process, and some of these ideas might get scrapped or revised along the way. I've linked the full government summary down below if you want to dive a little bit deeper. And if you did find this helpful, please make sure you like and subscribe, or drop a comment if you have some thoughts.